Good day, Crime Talk aficionados. We have a great show for you today. First, we're going to talk about the advanced DNA testing in the Bryan Kohberger matter. Then we're going to talk about the motion filed by Luigi Mangione's legal team to bar the death penalty. A guy felt that he couldn't leave any loose ends, if you know what I mean. The Karen Reed civil case may get to trial sometime in 2027. Hey, Dad, what's that on your phone? We have this day in legal history, our legal quote, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps as well. Before we get to today's docket, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. The report is literally emailed to you while you wait, and you're going to get all types of information. You're going to find out their social media presence, emails associated with them, not just the ones that they tell you about, phone numbers, criminal history. Are they married, divorced, liens, judgments, everything you want to know about somebody, including are they on one of those sex offender registries. So if somebody's coming into your life and you want to check them out, or you're not getting a warm, fuzzy feeling by somebody that's already in your life and thinking maybe it's time to go check them out. Go to crimetalksearch.com. Now, quick update. We talked about this last week. We had our Crime Talk keychain, bag tag, whatever you'd like to do with it. And we have them for sale. If you go to the link below, it'll take you right there to them. You can order them. We have had a pretty overwhelming response. Hey, I mean, $5 on something that's going to last forever. And people will say, oh, you're a Crime Talk aficionado when they see your keychain. Yes, they are. So go check that out. You can't go wrong with it. They're going fast, so get there now. All right, let's go ahead and open the record for Monday, September 22nd, 2025. And first, let's talk about the role of advanced DNA testing in identifying Bryan Kohberger. So we've talked about this before, and this was a big deal. Everyone wanted to keep ignoring the DNA in the Bryan Kohberger matter. Oh, it's still just a little trace DNA. Oh, you'd expect it to be there. No, you wouldn't. And your DNA wasn't there, nor mine, nor just about anybody else's, but his just happened to be on the knife sheath, him being referring to Bryan Kohberger. So obviously, back in November of 2022, the four University of Idaho students were fatally stabbed in their off-campus home there in Idaho. Now, a critical piece of evidence recovered from the scene was the leather knife sheath left beside one of the victims containing male DNA on its clasp. Now, this sample did not yield a match in standard law enforcement databases such as the Combined DNA Index System, or commonly referred to as CODIS, which typically identifies individuals or close relatives based on direct comparisons. So to advance the investigation, police transported the DNA sample to Ortham, a specialized forensic genetic genealogy laboratory in Texas. There, experts employed forensic-grade genome sequencing to construct a comprehensive genetic profile featuring hundreds of thousands of markers. Now, this method extends beyond conventional DNA analysis by enabling comparison with a distant relative in public genealogical databases, rather than relying on exact or immediate family matches, familial matches. So within 14 hours of receiving the sample, the laboratory generated the profile and identified key ancestral details. The individual was a multi-generational U.S. resident with Pennsylvania roots and a distinct Italian heritage. These characteristics narrowed the possibilities to just 2 families nationwide. Further, integration with investigative data, such as the suspect's presence in the area, ownership of a white Hyundai Elantra, a recent license plate change from Pennsylvania to Washington, and physical features like prominent eyebrows pinpointed Bryan Kohberger, obviously the criminology doctoral student there at the Washington State University. Subsequent surveillance and additional DNA testing included a sample from discarded items at his house, and that confirmed the connection. Now, obviously, Kohberger was arrested in December of 2022 and charged with the murders. And then in July, he pled guilty and received a life sentence. In fact, 4 consecutive life sentences without the possibility of parole. Now, the defense challenged the admissibility of the genetic genealogy evidence, arguing it violated constitutional protections and seeking to exclude expert testimony from the laboratory. They also highlighted unrelated DNA traces at the scene, such as profiles under a victim's fingernails and on other items, suggesting potential contamination or even transfer. However, the forensic experts emphasized the probative value of the sheath DNA, noting its direct association with the weapon distinguishes it from incidental transfers common in shared living spaces. The court upheld the evidence validity, obviously, and obviously the DNA contributed to the fact that Bryan Kohberger decided it was in his best interest to take a plea. So this case underscores the transformative potential of forensic genetic genealogy in solving crimes where traditional methods are going to fall short. By reconstructing extensive family trees from partial matches, it facilitates identification even for first-time offenders who don't have any prior criminal record, which would have resulted in their DNA being taken. Now, Ortham's technology has resolved other high-profile cases, including the identification of Rachel Marin's assailant and the remains of the Gilgo Beach victim, Karen Vergata, after decades where it went unsolved. Now, despite its efficacy, access to this testing remains limited due to funding constraints as it receives no federal support. So law enforcement agencies in some jurisdictions may lack resources to utilize it, potentially delaying justice. Now, advocates, include the victim's family and laboratory representatives, are pushing for broader implementation to ensure equitable application across all types of cases. Now, Stacy Chapin, Ethan's mother, has collaborated with Ortham to promote this goal, highlighting how the rapid DNA analysis not only brought closure, but may have prevented further harm by expediting Kohberger's capture. In summary, the precise DNA profiling and the genealogical mapping in this investigation exemplifies how advanced genetic techniques can bridge gaps in evidence, holding perpetrators accountable and enhancing public safety. Now, ladies and gentlemen, this technology is getting more and more incredible. Yes, there are great privacy concerns that are going to have to take place, and perhaps even regulation and laws, even though who likes more regulations and laws? But if you submit your information out there, you submit it to the world. If there are no limitations on it, guess what? They can use it, they can sell it, they can do whatever they want. So you got to be careful of that, obviously, if you're going to put it out there. But this DNA has literally come so far. When I first started practicing law, there were hearings, Daubert hearings on whether we could trust DNA. And now it just comes in automatically because it is so widely recognized and, for the most part, accurate. Really what it comes down to is the statistical analysis that has changed over the years because there's bigger and bigger databases. But when you hear numbers like the odds of it being someone other than the defendant are 1 in 17 trillion or quadrillion, it's a huge number. It's like it's tough to get around. And the fact that DNA is there and they're able to test it in even smaller and smaller amounts, it's going to be amazing, ladies and gentlemen. And with the modern technology of obviously the DNA, you're also getting all of the evidence as it relates to video evidence, because video is everywhere. It's really making it tough for criminals to get away with anything, which is a good thing. We don't want people committing crime. That's one of the things that the government is supposed to protect, our rights from being infringed, your right to life, liberty, and happiness and all that type of stuff, right? But it's getting to be amazing and a little scary on what it can actually do. Something to think about. Next, the motion was filed by Luigi Mangione's legal team to bar the death penalty. So Luigi Mangione's attorneys, obviously, he's the individual charged in the murder of the United Healthcare CEO, Brian Thompson, filed a very succinct 114-page motion on September 19th, seeking to prevent federal prosecutors from pursuing the capital punishment and requesting dismissal of the indictment. Now, the development follows a recent ruling by the New York State judge who dismissed terrorism-related charges against Mangione while upholding second-degree murder charges. Now, the 27-year-old defendant continues to face federal charges as well as an additional state charge in Pennsylvania, to all of which he has entered pleas of not guilty, and certainly he's entitled to the presumption of innocence. Now, the incident occurred back on December 4th of 2024 when an assailant, believed to be Luigi Mangione, wearing a face mask, fatally shot Thompson, who was 50, in a Midtown Manhattan shortly before his scheduled appearance at the United Healthcare Group's Investors Conference. Now, Mangione was apprehended after an extensive search and subsequently charged with multiple federal and state charges linked to the crime. Then in April of 2025, Attorney General Pam Bondi instructed federal prosecutors to pursue the death penalty in this matter. Now, the motion filed in the U.S. District Court for the Southern District of New York contends that the pursuit of capital punishment is driven solely by political considerations. It highlights the intense public scrutiny surrounding United Healthcare's practices, broader healthcare policy debates, information leaks, and the New York Police Department, an allegedly unconstitutional public escort by police, and repeated public statements by the New York City Mayor, Eric Adams, and the police commissioner. Now, these factors, according to the defense, elevated the case to international prominence, and the motion asserts that the case provided the incoming administration an avenue to express disdain for the previous administration and to promote its stringent stance on capital punishment through, obviously, a very highly visible prosecution. Now, Mangione's legal team outlines 6 specific instances in which they allege violation of the defendant's constitutional rights by Attorney General Pam Bondi, federal and state law enforcement, and Mayor Adams, thereby irreparably compromising the capital case. Among these, the attorneys criticize extrajudicial remarks made by officials in media interviews and on social media platforms, as well as the orchestration of a highly publicized transfer, describing as resembling the handling of a high-profile criminal figure, which they claim infringed upon Mangione's rights under the 5th and 8th Amendment. Now, following this event, Mayor Adams addressed the media, characterizing the incident as an act of terrorism and emphasizing intolerance for such violence without referencing the presumption of innocence or due process rights. Now, neither the office of the mayor nor the attorney general have made any further comments as it relates to that particular issue. Additionally, the motion accuses police of failing to shield the grand jury from potential bias stemming from Bondi's statement and rejecting defense efforts to present mitigation evidence prior to the decision on capital eligibility. Now, the defense further argues that the imposition of the death penalty in the instant contravenes the 5th and 8th Amendment by being applied in an arbitrary manner, and that the Federal Death Penalty Act is deficient in congressionally mandated constitutional safeguards. They contend that the government's actions in securing a death-eligible indictment involved unconstitutional and biased conduct, thereby undermining Mangione's due process protections. Portraying their client, the attorneys emphasized his academic and athletic achievements, noting descriptions from acquaintances as a compassionate, astute leader who prioritizes others. They described his trajectory as a once promising path, now severely disrupted. This marks the second such motion for Mangione's team. An earlier filing in April similarly labeled the death penalty pursuit as politically motivated, while New York's Judge Gregory Caro recently dismissed the state terrorism counts. He affirmed sufficient evidence for the remaining charges, including that of second-degree murder on the state case. Now, Mangione faces 4 federal counts related to Thompson's death, alongside the New York state charges encompassing second-degree murder. Now, the federal prosecutors are required to respond to the motion by October 31st, and Mangione is set set to appear in federal court on December 5th of 2025, following the commencement of pretrial proceedings in the state case. Trial dates remain uncertain for both jurisdictions. So Mangione struck it big when they got rid of the terrorism counts in the state last week. So be it. The feds, they've indicted him on murder and they've presented aggravation, and the feds can decide to go forward. Now, I understand the defense attorneys, and Mr. Mangione has very fine attorneys who are going to do everything they can to save his life. But the argument that the death penalty is political, well, yes, it can be, but that's not a basis in which to strike the death penalty from the case. The fact that it's been arbitrary and capricious, being used in an arbitrary, capricious manner, now that argument's been made thousands of times. The legislature, Congress, the United States Supreme Court has said you can have the death penalty, and the jury gets to decide aggravating and mitigating factors. That's really what it boils down to. All the other stuff about the perp walk and everything like that, that's not a legal basis in which to have the charges thrown out. It's an argument to the jury for sentencing, but I get it. The defense is doing what they need to do. They need to create an appellate record so that if, in fact, there is a conviction, all those items have been litigated. But I would guarantee you the defense knows that they know that it's a very slim chance that that is what is going to take place. We'll have to wait and see. Maybe the judge will surprise us, but at the end of the day, what you think normally is going to happen happens. Anyway, obviously, Mr. Mangione is entitled to the presumption of innocence. And it's interesting because I was going through the comments this weekend and somebody said, Scott, I appreciate everything, but, United Healthcare has been so bad to so many people. I get it. You may not like your insurance companies. I despise insurance companies most of the time. They never cover what they say they're going to cover. They try to nickel and dime you on everything. I get it. They're running a for-profit business in most cases. And the reality of it is their goal is to keep as much money as they can while paying out as little as possible to potential claims. But no matter how bad your insurance company is, and I did a quick search, couldn't find my insurance company sucked, therefore it was okay for Luigi Mangione to kill the CEO by assassinating him by shooting him in his back. It's not there, ladies and gentlemen. And so a jury will ultimately decide whether it's, murder after deliberation or if there's a lesser degree in the federal case as well. And who knows, the chances of Luigi Mangione, even on a federal death penalty case in New York, probably getting the death penalty is about slim to none, but it is a tool for the prosecution to negotiate. And once again, as you'll see, oftentimes in death penalty cases, we'll go do life without the possibility of parole. Just don't kill my client. We saw it in Kohberger. We may see it in Luigi Mangione as well. Next, when you commit a crime, you can't leave any loose ends. So a young individual, a 27-year-old man in California, has been charged with the murders of a woman and two others, allegedly to prevent her from providing testimony regarding an earlier assault in which he strangled her, according to the police and the arrest affidavit. Now, the suspect reportedly stated that he could not tolerate unresolved matters or individuals discussing his actions. So please meet Joseph Vincencio. He is accused of fatally shooting 26-year-old Tara Lynn Taylor, her 24-year-old roommate, Janessa Lurie, and 26-year-old Mac Ryan in San Jose. Now, police received several reports just before 12:30 a.m. on Tuesday of last week concerning gunfire and a woman calling for assistance in the 200th block of Chenoweth Avenue. Upon arrival, police discovered the woman outside the residence with at least one gunshot injury. She was transported to the hospital and was later pronounced deceased. Inside the home, police found another woman who was declared dead at the location, along with the man who rushed to the hospital but subsequently died of his injuries. According to the arrest affidavit, Taylor had contacted the San Jose police on Monday, shortly before the incident, to report that Vincencio had struck her in the chest and strangled her the previous day. Police observed visible marks on her neck supporting her account, and Lurie confirmed witnessing the domestic violence. Now, although no arrest was made at that time, Vincencio allegedly returned to the residence earlier Tuesday and carried out the shootings. Guess what? Surveillance footage reportedly showed him leaving the scene with a very distinctive bag, which he discarded in a sewer. Police recovered it, which contained the firearm. Investigators interviewed a witness who reported that Vincencio had expressed concern about potential repercussions for assaulting Taylor, stating he could not afford loose ends or gossip. The witness advised against any violent action. Following the incident, the witness noted that Vincencio used their computer to research homicides in San Jose. A second witness informed police that when questioned about the killings, Vincencio admitted to resolving a conflict with a male resident at the apartment. Now, the arrest affidavit characterized the initial assault as a domestic violence, but did not specify the nature of the relationship between Vincencio and Taylor. Reports indicate that Vincencio has a prior criminal record extending back several years. In 2019, he faced charges of discharge of a firearm at the Martin Luther King Library and the parking structure. His father previously described him as having an interest in firearms and challenges related to mental health. Wow, anger control issues, gun issues, and mental health issues. What could possibly go wrong? Anyway, Vincencio is scheduled for court on October 24th and remains in custody. Now, if this wasn't such a gosh darn serious case, it'd probably be worth dumb criminal status, just simply for the fact that to minimize it, you should never, ever, ever put hands on a woman, ever. But this probably wasn't something that was going to get him sent to prison. Now, this gentleman is looking at spending the rest of his life in prison if he is ultimately convicted. 2 murders, for goodness sakes? Cleaning up loose ends? What crime novel did this guy think he was living in? Stupid. Next, the Karen Reed civil case had a status conference today, and well, guess what? We may get a trial sometime in 2027. So Karen Reed made a courtroom encore performance today, facing off in a civil suit lobbed her way by the family of her late boyfriend, Boston police officer John O'Keefe. Not one to play defense alone, her attorneys cleverly disclosed intentions to counterpunch with lawsuits against the Massachusetts State Police and a cast of characters central to her infamous murder trial. As you may recall, back in June, a jury deftly sidestepped the gravest accusations against Reed in O'Keefe's demise, acquitting her of the heavy hitters. She had been charged with striking him down and abandoning him to a frosty fate outside a Canton residence there at 34 Fairview Road following a boozy evening of drinking in January of 2022. Civil proceedings, of course, operate under a gentler evidentiary threshold than their criminal counterparts of proof beyond a reasonable doubt. Anyway, this particular claim initiated last year after Reed's initial criminal bout ended in a hung jury and a mistrial, pursuing damages in excess of $50,000. That's for a jurisdictional limit to get it into the district court. Now, during the hearing, Reed's counsel, Damon Segelson, artfully outlined her strategy to pursue claims against state police figures like Lieutenant Brian Tully, Sergeant Yuri Birkenek, and the now dismissed trooper Michael Proctor for alleged civil rights infringements and collusion. Extending the roster, she claims to target Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, those present in the fateful home for similar conspiratorial conduct and civil rights violations. Now, the house guests masterfully shifted the spotlight from their own doorstep to Miss Reed's. Miss Segelton quipped in court, orchestrating an unverified front to bury an inquiry into the indoor enigmas. Further broadening her legal salvo, Reed intends to hold the town of Canton accountable for purportedly neglecting to safeguard a police garage, inviting negligence in the narrative. The civil drama unfolds in Plymouth Superior Court under Judge Daniel O'Shea, a departure from the Norfolk Superior Court venue presided over by Judge Beverly Canone in the criminal saga. Leading the plaintiff's charge is Paul O'Keefe, John's brother, joined by the deceased's parents and his niece, whom he had been the guardian of at the time of his demise. Now, the complaint artfully contends that Reed alleged carelessness and brazen indifference precipitated O'Keefe's tragic end, while accusing her of spinning a deceptive yarn about the incidents. Karen's tipsy drive culminates in a reverse maneuver that fells JJ, leaving him to perish in the chill, and she was acutely aware of the impact, asserted the O'Keefe family attorney Mark Diller. Evidence underscores that Miss Reed ought to have foreseen the profound harm her audacious actions would inflict on these grieving parties. In a twist of accountability, the family also directs claims at C.F. McCarthy and the Waterfall Bar and Grill there in Canton, faulting them for fueling Reed's evening libations. Notably, in her criminal proceedings, Reed's sole conviction was for driving under the influence, earning her a probationary sentence of 1 year. Now, Reed, ever the strategist, seeks to exercise the emotional distress portion from the suit, arguing the family lacks ringside seats into the purported vehicular mishap. Now, Miss Reed's queries or denials regarding the collision or her musing about a rogue snowplow fall short of deliberate malice towards the plaintiff, her defense astutely notes. For the simple skirmish, Reed reassembles much of her legal ensemble, with Alan Jackson reprising his starring role from the criminal case, bolstered by Aaron Davis and Charles Waters, and of course, Mr. Seligans. Now, Judge O'Shea, peering into the procedural crystal ball, anticipates a protracted and intrinsic journey ahead, reserving judgment on the dismissal until a hearing which has been set for November 21st. My intuition suggests trial readiness won't bloom by spring, he observed with judicial foresight, which means, yes, probably 2027 we will actually have a trial date, ladies and gentlemen. Next on the docket. Hey, Dad, what's that on your phone? Oh, what a delightful family vacation finale. Picture this: a doting dad from Tennessee, fresh off a sun-soaked carnival cruise with his glowing pregnant wife and a brood of 8 kiddos, 7 of whom so generously adopted after playing foster hero to about 20 others. Strolls into the port there in Miami only to get VIP treatment of a random secondary search, because nothing says welcome home like border agents rummaging through your digital dirty laundry. Please enter Jason Allen Miller. This guy's 48 years old, the picture-perfect patriarch who is a moment of sheer brilliance hands over his Samsung Galaxy passcode without a fuss. Lo and behold, the sleuths from Homeland Security uncover a treasure trove of photos and videos featuring young girls in the most appalling scenarios imaginable. And get this, one folder, cheekily dubbed 6-year-old Rare, boasts a whopping 45 gems implying these subjects were around 6 years old. How utterly charming, especially since his own little ones tagging along range from, you guessed it, ages 5 to 12 years old. Talking about keeping it in the family-aged bracket. Now, in this chat with the police, Miller casually confessed that nobody else touches his phone. And oh yeah, he was fully aware of the illicit stash. Shocking, right? From there, it's off to the Broward County Jail, courtesy of the United States Marshal, followed by a swift shuttle back to some federal holding facility. Now he's staring down charges for possession and transporting child exploitation material, with a potential of a 30-year timeout if the gavel swings his way. But hey, Mr. Miller's not alone in this exclusive club, just like Pennsylvania's Matthew Kutcher, who nabbed in April at the same port with his own video collection, leading to a plea deal for at least a decade behind bars. Pro tip for cruisers, maybe leave these souvenirs to fridge magnets next time. Now, of course, this all falls under the Border Patrol's routine phone probing playbook at the U.S. entry ports, airports, seaports, and you name it. No warrant needed, folks. U.S. citizens aren't legally obligated to cough up passwords or unlock their little gadgets. But guess what? They'll play a little hardball and you'll earn yourself a scenic delay some probing questions, or even device confiscation. Non-citizens, they might just get the boot, because nothing enhances border security like turning your vacation glow up into a total buzzkill. Yes, ladies and gentlemen, you have no expectation of privacy coming across the border. You can be searched for anything, anytime, anywhere. And yes, if you don't cooperate, they will say, fine, that's very good. We love that you exercise your constitutional rights. We're just going to seize that phone from you, probably get a warrant, and, we'll see what's going on. That would be the thing to do, particularly if you have some inappropriate photographs on the phone. Once again, ladies and gentlemen, you can't make this stuff up. And talk about the guy accused of having child exploitative materials on his phone with the age of about 6, just happened to be a foster parent. Now, I certainly would not characterize foster parents as all of them engaging in some inappropriateness. I would not. I know people that have been foster parents, and I thought obviously they are saints. They're a much better human being than I would ever be. But oftentimes you find that some people run foster care as a business enterprise to get as much money for adopting kids and spending as little as possible. And then others use it so that they can get access to children of a particular age. Once had a client that would take people in for foster care, but he would only take young Hispanic men between the ages of 7 and 12. After that, they were just a little too old for him. Be careful, ladies and gentlemen. Be careful out there. It's dangerous. Next, this day in legal history, September 22nd, 1776, U.S. spy Nathan Hale was executed after he was captured by British forces during the American Revolutionary War. Hale went to British-occupied New York to gather intelligence on military operations. He was captured and executed within a month, purportedly declaring, "I only regret that I have but one life to lose for my country," before his death at the prime age of 21. Next, September 22nd, 1692, 6 women and 2 men were executed for witchcraft in Salem, Massachusetts. Somebody starts a rumor, throw them in the river. If they float, they're a witch. If they don't float, they're a witch. Doesn't really matter. They're a witch. Let's burn them. That's what they would do. Next, September 22nd, 1933, the Barker Gang robs the Federal Reserve mail truck in Chicago, killing an officer, an event that highlighted federal crimes laws and led to increased focus on kidnapping and bank robbery statutes. By God, it happens once. There must be a law for this. September 22nd, 1975, Sarah Jane Moore attempts the assassination of President Gerald Ford in San Francisco, leading to federal legal proceedings on assassination attempts and gun control discussions. Have I told you, ladies and gentlemen, that this is all the same? Nothing's different. Go back thousands of years. All the same stuff. Next, our legal quote of the day. Wherever law ends, tyranny begins. John Locke, Second Treatise on Government, 1690. It's almost like they had studied what dictators had done previously. Amazing. Amazing, isn't it, ladies and gentlemen? None of it's new, but we act like it's all new. And finally, our dumb criminal of the day. In a bizarre twist straight out of another Florida farce, police report that a 48-year-old woman moonlighting as an escort allegedly turned a can of silly string into an impromptu weapon during a barroom confrontation. The incident, dubbed a colorful fracas by police, unfolded at the OCC Roadhouse in Clearwater, Florida last Thursday evening. According to the arrest affidavits, Christy Watts approached Jesse Hammock, a 33-year-old masonry contractor, and unleashed a torrent of silly string until the canister ran dry. Not content with mere entanglement, she purportedly then hurled the empty container at him, striking his forehead and inflicting a minor cut. While the document remains silent on any underlying motive or prior connection between the parties, Ms. Watts faced charges of battery. She was detained overnight before being released on a $1,000 bond the following day. Adding a layer of intrigue, court records link Watts' phone number to an online escort profile under the alias Taylor. The listing, featuring explicit imagery, highlights her age and availability in the Clearwater area. Don't worry, should go as far as St. Petersburg. A fresh update proclaims that Taylor is back in the saddle and ready to ride, detailing her offered services with unapologetic flair, ladies and gentlemen. I guess the world's oldest profession only takes a halt for a little barroom brawl and a little time to bond out of custody. That's all we have for today, ladies and gentlemen. Hope you enjoyed the show. We'll see you tomorrow. And remember, the Constitution matters.